Hello, my name is Vikram Shroff. I'm going to be presenting on employment termination in India. The reason for this presentation is that in recent times the termination related situations have increased and employees have started litigating against their employers for wrongful or illegal termination. So I thought it might be good to give a snapshot of the laws governing termination of employment in India. Uh, in India, we have national level laws as well as the state level laws which contain provisions on employment termination, and those need to be followed and complied with prior to terminating employment in India. Failure to comply with those laws could amount to illegal termination, and the courts may grant reinstatement with continuity and back wages. The laws that contain provisions on employment termination include the Industrial Disputes Act, a national level law, the State Specific Shops and Establishments Act, the Industrial Employment Standing Orders Act, and certain other state laws, for example, the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act. In addition to these laws, the provisions of the employment contract and the HR policies need to be complied with to ensure that the termination is just and for the right reasons, so that even if an employee drags the employer to the court, the employer will succeed in the termination case. Now, there are different modes of employment cessation, which could be as a result of employee-initiated cessation or an employer-initiated cessation. When we talk of an employee-initiated cessation of employment, it is largely by way of a voluntary resignation on the part of the employee. However, if it's employer-initiated cessation, it could either be termination for cause, termination for misconduct, or it could be a retirement upon reaching the age of superannuation. There are also situations where employment may cease in the event of expiry of a fixed term of the contract. It must be borne in mind that Indian law does not permit an at-will employment situation. By that we mean that an employer cannot hire and fire employees at his will, and needs to ensure that there is a reasonable cause or an act of misconduct on the part of the employee prior to terminating employment. So let's just talk a bit about the different modes of employment termination. We started with voluntary resignation on the part of the employee. Resignation, that's in situations where the employee issues a resignation letter, that resignation needs to be accepted by the employer. There have been situations in the past where in cases where the employee issued the resignation and withdrew it before the employer could accept it, and those kind of cases have gone into litigation, whether was there a need for the employer to accept it, or was it deemed to be a resignation. So it is generally a recommended approach that the moment an employee issues a resignation, that resignation gets accepted by the employer. The documentation would, in case of this mode of termination, would basically be a resignation letter, a resignation acceptance letter, and in certain situations, a separation and release agreement. The slides also provide the financial obligations of the employer upon a voluntary resignation on the part of the employee. It must be borne in mind that the resignation needs to be voluntary and not forced. In situations where the employee can prove that he was forced to sign a resignation letter, it's quite likely that the courts would award reinstatement. On the other hand, termination of employment could be initiated by the employer, but that could be done only in two broad ways. One is for a reasonable cause, and the other is for misconduct. When we talk of reasonable cause, it includes examples such as poor performance, redundancy, loss of confidence on the part of the employer. These situations are obviously not provided under law and will will vary based on case-specific situations. The documentation in case of a employer-initiated termination for reasonable cause would largely be a termination notice issued by the employer, and in cases where the employee is willing to sign, the employer could also have the employer sign a separation and release agreement. On the other hand, the employer could also terminate employment for what we call misconduct. Misconduct is nothing but some sort of a stigmatic termination by the employer. The law provides examples or acts that constitute misconduct. For example, damage to company property, harassment by the employee, theft, insubordination. Those are a few examples of misconduct that's provided under law, but it is generally recommended that the exhaustive list of acts that could constitute misconduct be provided in the HR policies or the employee handbook. It is important that the employer conducts an internal disciplinary inquiry prior to terminating employment for an act of misconduct. And in cases where this internal inquiry is not followed, the courts may treat the termination as illegal and award reinstatement to the employee. It is only when the act of misconduct is proved by way of this kind of an internal inquiry will the employer be able to terminate employment. The financial obligations in case of termination for misconduct would basically include wages up to the last date of employment, payment for accrued but unused leave, and gratuity as per the Payment of Gratuity Act. The broad process that the employer needs to follow in case of an internal inquiry would basically include issuance of a charge sheet, appointment of an inquiry officer, issuing a notice of inquiry to the employee, conducting the inquiry inquiry, and holding an ex parte inquiry in situations where the employee does not present himself, and eventually issuing the inquiry report. In the inquiry report, when it is proved that the employee indeed was involved in an act of misconduct, the employer can go ahead and terminate employment. It is critical that the principles of natural justice are followed while conducting such an internal inquiry. It is also possible to suspend the employee during the internal inquiry, especially in situations where the presence of employee within the office premises could be harmful to the interest of the employer, especially in relation to conducting such an inquiry. It is critical to note that the punishment that's inflicted by the employer after conducting the internal inquiry should be proportionate to the gravity of the misconduct and should take into account the past records of the employee. The principles of natural justice would basically include the right of a fair hearing, the parties to be given a fair chance to present their case before the inquiry officer, and ensuring that the inquiry officer is not biased in the sense of the inquiry proceedings. If the principles of natural justice are not followed during the inquiry process, it could very well be that the courts could require the employer to hold a disciplinary inquiry all over again. So that's a bit of a snapshot in terms of employment termination. Please do feel free to write to me at vikram.shroff@nishithdesai.com should you have any questions. Thank you.